Ladies and gentlemen, we're about to get started. If everyone can take a seat. This is a meeting of the City of Pickering's Election Compliance Audit Committee. I'm the chair of that committee. My name is Paul Jones. Other members of the committee are Mr. Don Hudson and Mr. Joseph Brown. Don's to my left, your right, and to my right, your left, is Mr. Brown. Just as a matter of procedural matters, we will allow pictures and video of the session. We would ask, however, that you do it inconspicuously, and please, if you would use the press area from which to do it. Okay? As I said, we want it to be as inconspicuous as possible. So, there's a number of things we have to go through this evening. There is an agenda. I assume it was publicly available. We'll be adopting minutes of our May 26th meeting. We'll be hearing a presentation from our solicitor. She'll be giving us an outline, setting the stage, if you will, as to the responsibilities and the obligation of the committee this evening. Give some context to the daily meeting. We'll be hearing from William Wilson and Bernard Naiman, who are the auditors who do the compliance audit. We'll be hearing from the persons that made application originally for the compliance audit to be conducted. That's Mr. Ian Cumming, David Steele, and Yolanda Dusak, if she happens to be here. We haven't heard from her recently. Yolanda here? Okay. We'll be hearing from no other persons. That's in accordance with our procedures as set out when this committee was first created. We'll be hearing from Mr. Dickerson, Councillor Dickerson, and his legal counsel, I assume. And then the committee will have some questions, obviously, and we'll have to deliberate and be making a rather serious and somber decision, one way or the other this evening. Okay. So, first order of business. Any members of the committee have any disclosures of interest, pecuniary or otherwise, bias and interest that you wish to pick up? None noted? Okay, the committee last met on May the 26th of 2011, and we have minutes of that meeting. And does someone want to move their adoption, please?
Move their adoption.
Okay. Any errors or omissions? Any corrections, additions, deletions? Anyone want to know? None? Okay, all those in favor? Motion carried, and it's adopted. Okay. I think I've given you some context already in terms of an opening statement. I said we want to hear from our solicitor who will give us a framework for our deliberations this evening. Jody Johnson, please.
Thank you, Mr. Chairman. As noted by Mr. Jones, my name is Jody Johnson, and I am I'm legal counsel to the Compliance Audit Committee. And my role tonight is to provide an overview for the committee and for those present as to what the purpose of the meeting tonight is, what the legislative framework is that the committee is operating within, and importantly, what this meeting is and what it isn't, and what jurisdiction and authority the committee has, and what the nature of the decision before the committee is, and the framework within which the committee will operate this evening. I preface my remarks by telling you a little bit and reminding the committee and those present about the creation of the Compliance Audit Committee. Municipal elections in Ontario are governed by a piece of legislation called the Municipal Elections Act 1996, and it's the statute that sets out the rules together with its regulations enacted by the province and administered through the Ministry of Municipal Affairs and Housing to govern municipal elections. In the Municipal Elections Act, sections 66 to 82.1 inclusive, are devoted to campaign finance rules. And throughout these rules, the principles of accountability and transparency in the financing of municipal election campaigns are evident. Subsection 81.11 of the Municipal Elections Act compels municipal councils in Ontario to establish compliance audit committees. This is a little bit of a change from the regime that was in place under the legislation prior to the 2010 municipal election. In previous elections, the Municipal Elections Act provided that municipalities had the option of creating a compliance audit committee. A committee could be created to consider requests for compliance audits under the Act, and if no committee was created, any compliance audit requests were heard by municipal council as a whole. So throughout Ontario, prior to the last municipal election, there was a real mishmash across the province of whether compliance audits were dealt with by a committee or by council and how those matters proceeded. The province of Ontario decided prior to the 2010 municipal election to amend the Municipal Elections Act to make compliance audit committees mandatory. What the effect of that was to remove the consideration of requests for compliance audits and any review or consideration of audits that result from those requests from the hands of council. They put those decisions and those matters within the hands of the Compliance Audit Committee, and it's required that no members of municipal staff, no members of council, and no persons who are candidates may sit on that committee. In essence, the province chose to create a regime whereby a separate independent body, though appointed by council, does not contain members of council or its staff, meets to review these matters. Under the provisions of the Municipal Elections Act, the term of office for the Compliance Audit Committee, which was appointed prior to the election, so the committee had to be appointed back in October, way back before the election took place, and the committee sits for the term of office that council sits for. So the Compliance Audit Committee sits for the same term of office that council does. What I think is important for people to understand about this evening and for the committee to be reminded of is what the committee's role is in the compliance audit process at this stage. As you are aware, the committee received 3 requests for a compliance audit of the campaign finances of candidate Doug Dickerson and approved that request and ordered a compliance audit. Under the statute, any person can appeal the decision of the committee. That decision was appealed, and the committee's decision was upheld by the Ontario Court of Justice in the audit proceeding. What the Municipal Elections Act provides in subsection 81.14, and I'm going to read it because I think it's important to have the wording, everybody to understand clearly what the committee's authority and jurisdiction is tonight. The section says, the committee shall consider the report within 30 days after receiving it. So we fall within that requirement this evening. This is the meeting whereby the report is being considered and it's within the time frame. And the committee may, this is a discretionary word, the committee may, A, if the report concludes that the candidate appears to have contravened a provision of this act related to election campaign finances, commence a legal proceeding against the candidate for the apparent contravention. B, if the report concludes that the candidate does not appear to have contravened a provision of this act relating to election campaign finances, make a finding as to whether there were reasonable grounds for the application. So the committee must consider the report, and the committee may simply consider the report and receive it, or may determine to commence legal proceedings against a candidate if there are apparent violations disclosed in the report. If there's a report where there are no apparent contraventions disclosed, then the committee may make a finding as to whether there were reasonable grounds for the request. The committee tonight is not about determining guilt, innocence, contravention of the act, or no contravention of the act. The committee is not making a finding of evidence and looking at the details of whether there is a conviction, for lack of a better sense of a word. That is a role for a different part of a process under the Municipal Elections Act. There's no, quote, penalty to be imposed by any Compliance Audit Committee decision tonight, whether it's going to commence legal proceedings or not. This is one step in a 5-part process that's set out under the Municipal Elections Act. I also note that the Municipal Elections Act provides outside of the Compliance Audit Committee framework that any person can lay a charge or take other legal action at any time regarding an alleged contravention of the Act. So that's a separate piece and a separate section under the Act. The Municipal Elections Act creates two classes of contraventions in its framework. What's called corrupt practices and what is referred to as less serious offenses relating to campaign finance rules. And the municipal election campaign finance rules operate on a system of self-reporting. Candidates are obligated to fill out information and submit it to the municipal clerk, which outlines expenses, income, and all of the financial activities of a campaign. Those financial statements are available to the public, and anybody can review them, and from that stage, request an audit or not. But the courts have recognized that there really is a 5-part procedure followed in reviewing the financial statements of a candidate. I'm going to quickly run through those so you understand that framework. In the first part, a citizen can apply for a compliance audit, and the Compliance Audit Committee must consider that application. If the committee refuses the application for a compliance audit or orders or allows the application for an audit, there is an appeal to the Ontario Court of Justice. If an audit is going to proceed, the independent audit must be conducted by an independent auditor licensed under the Public Accounting Act. And the Compliance Audit Committee, as I've said earlier, must consider the compliance audit report within 30 days from receiving it and determines whether to commence legal proceedings against a candidate or not. The last stage of the proceeding is a legal proceeding itself, often referred to as a prosecution. And that's the last stage. And in that stage, the candidate would have the benefit of full natural justice protection and can employ charter rights. And that's carried out through the laying of charges and through the whole process of a proceeding before a judge. So tonight, the Compliance Audit Committee for the City of Pickering is in receipt of the Compliance Audit Report for the candidate Doug Dickerson, resulting from the 2010 municipal election. And tonight is the time to hear further from the auditor, from the various applicants for the compliant audit, and from the candidate concerned. The committee then shall make a determination as to whether there should be a legal proceeding commenced or not, and the committee will consider the nature of the findings in the compliance audit report, and may consider many other factors, which I'm going to talk about in a few minutes. It's also important to understand that the nature of the committee's decision is a discretionary decision, and the committee has to employ a framework of procedural fairness, so all of those concerned have a right to be heard. The committee may ask questions of any person appearing before it. The courts in Ontario have considered the matters involving compliance audit reports and matters involving election campaign financing. And the courts, right up to the Court of Appeal, have determined and upheld that the power, discretionary power, such as the power that the committee is exercising this evening, is to be exercised for the purpose granted. So within the framework of the Municipal Elections Act and understanding the campaign finance rules, the decision maker, being the Compliance Audit Committee, has to make a decision. The committee cannot simply default or deflect from their obligation to consider the report under the Act. Decisions cannot be based and cannot be considered grossly unreasonable, so you have to consider the totality of the information that you have before you and that you will hear. The courts, as I said, have very, very clearly set out that there are various factors that go into a committee's decision-making process. And I want to very briefly run through the kind of decision-making framework that the court has identified and upheld. And the Superior Court of Justice, upheld by the Court of Appeals, found that any decision made by the committee should endeavor to maintain the confidence of the electorate in the election process. And any decision shall endeavor to maintain the integrity of the election process. Any decision shall be made to enhance the values of public accountability and transparency. Decisions must consider the scale of any apparent contraventions disclosed in a report. The decision must be reasonable, fair, and most importantly, not grossly unreasonable. One must not endeavor to advance political agendas or engage in personal animosity or bias. And there's a principle under the law that one should not prosecute modest apparent contraventions. So there's a whole series of things for the committee to consider. Another thing the committee can consider is what the range of potential penalties would be under the Municipal Elections Act for any finding, any conviction or any finding by a court. And look at things like what is the nature of the penalty, the range, ranging from fines to losing seats to not being able to run in the next election. The Elections Act, as I've indicated, has a whole range of penalties, and though you aren't imposing penalties, the potential outcomes can be considered. The cost on both a broad and small scale can be considered. Cost to the community, cost to the persons involved, cost to the candidate, cost to the municipality, and cost to the taxpayer. Whether any legal proceedings, whether the legal proceedings, if they are to be commenced, meet the purpose and intent of the Act in maintaining accountability, transparency, and public confidence in the electoral process, and whether an audit report and the findings itself are alone enough to equal a sufficient penalty, or sufficient, not penalty, that's the wrong word, but to equal a sufficient deterrent for other instances in the future, other candidates, other people looking at the situation. That's one of the principles in the Act when you look at the penalty provisions, of principles of deterrence as well. So in summary, the Municipal Elections Act is provincial legislation which has been enacted to establish the rules regarding the conduct of municipal elections and election campaign financing in an effort to provide accountability, transparency, campaign spending limits, and campaign contribution limits, all in an effort to enhance a fair electoral process and create a level playing field. I remind the committee that the committee is very clear in subsection 8114 what the committee's authority and jurisdiction is in considering the report and making any decision whether to take any further steps. And the committee will have the opportunity next to hear an overview from the auditors of the report and its findings. You'll have an opportunity to ask questions of the auditors. Then you'll have the opportunity to hear from those ratepayers and the citizens who requested the audit, and finally to hear from the candidate, and at that point consider the report and carry out your deliberations.
To read the whole darn thing. My understanding is that the committee has already done so on at least once.
And at least.
Okay, thanks very much. As the chairman indicated, I'm William Wilson. I'm a licensed chartered accountant that has conducted the compliance audit with Mr. Naiman, chartered accountant. There are four things that I'm going to say. The first is that in the report, in order to provide assurance to the committee as to the robustness of the credentials of the compliance auditor, and that we not only meet the threshold requirement of the Act, but we bring with us extensive experience, and we are each of us, I think I can say, expert in this area, both individually and collectively, and we've set out a few particulars in Appendix C. Mr. Naiman has audited over 6,000 election audits. I chair the licensing board for the province of Ontario, and have most of the alphabet after my name, and have done numerous election audits myself, as well as sitting on the federal task force, and authored the most recent revisions to the guide that is used nationally, along with my colleague. The second point I want to say is that our job under the Municipal Elections Act is to prepare a report that outlines any apparent contravention, and is not scoped or limited by the complaints that may have been made in the first instance. what we are to report is apparent contraventions based on review of the report, audit procedures, discussion, inquiry, and conducted in accordance with Canadian auditing standards, and that we have done. Which brings me to the third and fourth points that I want to emphasize. We have included at Appendix A our findings. There are a dozen findings and a comment. These are the apparent contraventions that we have identified as a consequence of our audit. Some are more important than others. Some might be considered modest with reference to the standard referred to by the courts. Two stand out as particularly notable in our review. The first of these is referred to in the report under items 6 and 10, which is the payment of just over $11,000 in a particular wage. We found that the original financial statement file, which the auditor stated should include this amount as subject to the limit, which puts the candidate in contravention of the Act by exceeding the spending limit. We concurred on the basis of evidence and additional powers available to us under the Public Inquiries Act, not necessarily available to him, that his finding was correct and the candidate had clearly and materially exceeded the spending limit. The fourth and final item, the second particularly impressive finding, was the expenditure of approximately $14,500 on alcohol, which was described as victory party appreciation notices. We were able to establish to our satisfaction that it was very clear that this expenditure did not relate to the campaign. What this means is that the amount is not, it's not that the amount is an expenditure in excess of the limit or the like. The significance of this conclusion is that the expenditure doesn't relate to the campaign. You have expenditures that are subject to the limit. You have expenditures that are not subject to the limit. But there is a third very significant category, which is expenditures that have nothing to do with the campaign. Now, under the current legislation, because any surplus is properly payable to the clerk and does not get returned in a subsequent election, if expenditures are made that fall into the third category, that they don't relate to the campaign, and they are shown on the financial statement in a manner so as to turn a surplus into a deficit, this means that funds that properly belong to and go to the City of Pickering do not go there, unless detected. In our report, we refer to this as a diversion of surplus. That is our fourth finding. Now, when you put the two together, it's about $26,000. The evidence is that the candidate had fully funded his campaign up to the limit plus a reasonable amount in excess somewhat over 5 weeks prior to polling day. But the collection of contributions, which is permitted, continued for that 5-week period and built up in excess of $26,000 or so. This is the amount that was expended in those two particular transactions. One, to a spouse who managed the campaign 2 days before the end of the calendar year and the end of the campaign period, several months after the polling day, and the alcohol I'll refer to. Of these two payments, There is no requirement in the Act that the payment of wages be reasonable. So what we've seen in the local newspapers is actually technically not correct. There is no reasonability requirement. If you've got the dough, you can spend as much as you want. This rarely happens, though, because if people do that, they're going to go over the spending limit. So the problem will usually solve itself. You have a surplus, you can't give it to your campaign manager because you're going to go over the limit. So it goes into surplus. So the original auditor was correct in identifying this as an amount of property subject to the spending limit. Those are the 4 points. I think I'll probably start repeating myself if I were to wax more eloquent about any of those. Are there particular questions? And I'm going to refer to the chair as to how we would like to handle this.
I believe there may be some questions based on our review of the audit. You want the audit now?
I think the time is probably now. I'm going to but I don't have any questions for myself at this time.
Will we ask questions later, or is this the time? Okay, I did have a couple questions.
Sure.
Just more as a clarification. And that related to the alcohol. So $14,000 worth of alcohol. Where was it? Was that at the party?
We were unable to find any evidence to support that it was at the party.
And I guess, was there any anticipation that that amount of alcohol would be used at a party? I don't
The victory party was held at Zero by the Bay. The total payment for the party was $1,500, which represented $1,300 in change plus a gratuity. Zero by the Bay has a liquor license that does not permit the serving of alcohol that is brought in. The alcohol was at the time of our audit present at Mr. Dickerson's house, and he's indicated to us that it was not used, it was not given away as appreciation in the course of the campaign, as I understand. So it does exist. Initially, what one expects may have occurred in an audit where there are large alcohol purposes that do not reasonably relate to a victory party, is that a month after polling day it is taken back to the LCBO for a refund. But they have computers, and their computers did not show any evidence of a refund, which led us to extend our inquiries into where the heck's the booze. And that was our finding. Bernard, who has over 5 decades of experience, are there particular, the chair may wish to provide you an opportunity